Thanks. So hello, everyone. Thank you, Mike, for that quick introduction. I am Liz Gray. I'm the State Director for the New Hampshire Small Business Development Center, and we're really pleased to be able to bring you another one of our webinars in our LEAF series. So today is going to be about contracts, do's and don'ts, led by Amy Cann. But before we get into that, I wanted to give you a quick overview of what SBDC is, who we are, and how we do our work, just in case you haven't met with anyone on our team yet. As you'll see on the slide, we are a cooperative agreement of USSBA, the state of New Hampshire, and UNH. UNH has been our host institution for 41 years, and we couldn't be more pleased to be a part of the UNH system. It's been a great working relationship. Similarly, it's wonderful to be connected to the state as well as to federal resources to be able to pull in a lot of great programs and services for all of our small business clients. Our main mission is to provide business advising and educational programs for small businesses. And when I say small, a lot of people think of businesses with less than 10 or 25 employees. But in fact, we work off of USSBA's definition of small, which is up to 500 employees. So we are actually able to work with 99% of the businesses here in the state of New Hampshire. Our advising team is set up regionally. You'll see we've got our Seacoast team that goes from the traditional Seacoast line up to Wolfboro, our southern team that pretty much goes from Franklin on south to the Massachusetts border and then over and picks up Cheshire County. And then our north and central region picks up the rest of the state. Our advisors are set up again regionally so that they have that local presence and local connection to lenders, other resource partners, the regional development corporations, chambers of commerce, to make sure that businesses, regardless of where they are in the state, they have those one-on-one connections to additional resources beyond our advising team. We work really hard to make sure that all of our business advising is very much individualized. It is always confidential, and we never charge anyone for the services that we offer. We work with businesses at every stage of the life cycle, whether it's I've got an idea and I've never started a business. I need some help figuring out how to create my first business plan, looking all the way through to I'm about to hire some additional employees, or looking at exporting or government contracting for the first time. And then all the way on through towards the end of the life cycle where I've been with my business for 30 years, I'm ready to sell it or pass it on to the next generation in my family. We are pretty proud of the impact that we have statewide here in New Hampshire. As you'll see here, our 2024 by the numbers, we supported 1,910 clients last year alone through our direct one-on-one advising. We helped 81 businesses get started and helped them also raise another almost $16 million in new capital. And then when you look at the economic impact across the state, we're providing $254 million in total economic impact to the state of New Hampshire. I couldn't be more proud of our small but mighty team of 18. And I do hope that if you haven't connected with SBDC yet, that you will do so. We've got a lot of really great programs that we offer in addition to our one-on-one advising. You can take advantage of the cybersecurity initiative where we've got free cyber audits. You have to sign up soon though, because that program, those free audits are actually going away at the end of this month. So if you are interested in getting one of those, sign up pretty much today or tomorrow is actually the last day. But some of the other great programs, again, the LEAF program is another one that we are so pleased to be able to offer you. Not only are we doing these webinars and workshops for our clients, but Amy and other attorneys and private consultants, whether they're part-time CFOs, QuickBook experts, or accountants, are providing an additional 5 hours of free time to our clients. And it's only free because we have some great additional federal funding that we've been able to tap into to be able to hire Amy and those other consultants to be able to give you those extra services in addition to working with our business advisors. We've got over 30 e-courses on our website that you can take advantage of at any time of day. Once again, free and available to you or to friends and colleagues that are also looking at starting a business, thinking about expanding their marketing efforts, or again, looking at government contracting or exporting. Lots of great resources on our website and those e-courses. I like to think of people getting home at the end of the day and, they have made dinner, cleaned up, put the kids to bed, and they're in their PJs and their fuzzy slippers on the couch. And they're like, you know what? I should do a little bit more homework on marketing or on financing. So that's when you pull out the laptop and you take a look at one of these e-courses. There's some other great programs that I encourage you to look into. If you're looking at government contracting, we have a small business matchmaker that takes place on an annual basis. Our Export Accelerator program is helping businesses create their first export business plan and then match you up with resources, whether it's SBA for financing opportunities, the state's Office of International Commerce to access some additional federal funding to be able to look at trade shows or getting your website translated into other languages so that you're more easily able to access markets in foreign countries. Our partnerships with UNH, we work so closely with the Center for Business Analytics, the student-run digital marketing agency, Voice Z, so you see that big Z there, as well as connecting our clients with MBA students through the capstone projects at the Business School Paul College. So lots of great ways to take advantage of additional resources. I highly recommend that you come and visit our website, nhsbdc.org, for more information on all of these programs. But I think you've probably heard enough from me in my quick intro on SBDC. Happy to answer any questions later. But it is truly my pleasure to be able to turn this over to Amy Cann. Amy blends legal expertise and business insight and empathy to deliver practical guidance during challenging times. She holds a law degree from the University of Maine School of Law, an MBA, and certifications in data privacy and cybersecurity, enabling her to address today's business and tech issues effectively. Amy teaches at UNH and Franklin Pierce School of Law and speaks nationally on business, employment, consumer, and technology topics. She's active in professional organizations and committed to social responsibility through pro bono work with 603 Legal Aid and support for local animal and wildlife rescues. Outside of work, she enjoys hiking, soccer, traveling, reading, and the beach. I don't know how, Amy, you have any free time to do any of these things, but we are so thrilled that you are part of the LEAF program and that you're taking this time to partner with us and to share some of your great insights on contracts, do's and don'ts. So with that, I will happily turn it over to you, Amy. Thanks again for joining us.
Thank you. I appreciate it. And, on that point, I slept about 5 hours last night, so I don't recommend doing that. I think sleep is super important, the older you get, especially. So, but yeah, it definitely is a balance. So hopefully today I can help you balance things better by starting off with good contracts, because it's not, doesn't probably go maybe like a week or two by before I have a client call or potential client call that has a contract issue. And usually it comes down to either they didn't have a contract, they had an oral agreement, which can be enforceable, but it's difficult if you didn't nail down details and there was a lot of assumptions. And I find people operate under assumptions a lot. And especially when you're friendly, you know the person, and that's the time to nail down details when things are good. Because when things go bad, if they do, that's not the time to try to figure things out and get an agreement in place. So hopefully today we can help balance again a little bit for you so you can understand contract issues, and we'll talk about some bad examples. I have some I'll share too with clients, and often the ones I see the most really lately are the ones where it's a multi-member LLC and there's no operating agreement, which means it defaults to the statute in New Hampshire, which does not really cover everything, or nor does it really cover the intent of the parties and what's best interest for everyone involved. So getting an operating agreement in writing if you are part of an LLC is really important, because I see that issue a lot. But with that, that background, contracts really are everywhere. Even if you're joining a gym, buying a house, if you've bought a house before, there's like stacks of paper to sign. Your kid's allowance in exchange for chores, that's actually a contract between you and your child to do what what you're going to pay them to do. Ordering DoorDash, anytime you click I agree on a website, there's all a contract involved with that. Sometimes it's a one-way contract. You don't really have a chance to negotiate. Like if you're clicking, I agree on Microsoft Office or Chat GPT or you name it. You don't have an opportunity to negotiate. It's either you take it or you leave it. So you either agree or you don't get to use it. And that may be the same way with your gym. I'm sure Planet Fitness or the Works or any other place isn't going to individually negotiate your contract. So sometimes you have no choice. And your choice really is just not to do it, right? Not to go on the website, not to sign up with a gym, whatever, is applicable. So, and that's why it's important though to read the contracts, because sometimes it's not in your best interest to do it. For example, anytime you use AI, you're licensing them to use what you enter into their system. That might not what you want to do. And for example, like losing IP can happen that way. If you enter things into Chat GPT or like I use Perplexity AI, and it's confidential, trade secret, IP information, you're losing that essentially. And that's the risk that a lot of employers have with employees. But that's a whole other topic. So, but just to break down the elements of a contract to make sure it actually is valid, there has to be an actual offer. Someone has to offer. That's non-acceptance. That's a counter offer, which kind of restarts the process. And now you've received a counter offer, so it's your turn, so whether accept or not, or counter offer and continue the negotiation. So those are two elements. And then the most important part probably is really the consideration, because you can't force a promise. There has to be consideration. Usually it's exchange of money or it's an exchange of services, products for money, or sometimes it's something, you promising to not do or do something that requires your effort, time, requires you to lose out on something. There has to be some trade-off that you're getting. It can't just be a promise, like I'm going to promise to wash Liz's car every Monday. She'd love that, I'm sure, but what do I get out of it, right? So that would be an enforceable contract. If I said right now, Liz, I promise you I will wash your car every Monday morning, and she's like, great, doesn't offer anything else, that's not going to be enforceable. It's just a promise. There's no consideration there. If she says she'll give me $500 to wash her car every Monday morning, I'm totally in, by the way, Liz. And now she's offered something in exchange, right? For my service, she's providing value. And another element really is meeting of the minds. So if you think that I'm trying to sell my antique little Matchbox car, and I'm actually talking about my actual sports car, and we sign a contract, there's no meeting of the minds there. We're not talking about the same thing. So that's also an element there. So just be aware that sometimes you make an offer which can look like different things. It could look like even like a quote or a proposal. If it's construed as an offer, someone accepts, there's an exchange of consideration, you guys are talking about the same thing, you may have just created an enforceable contract. So be careful when you go and you're accepting and agreeing and signing things, because you want to make sure you're aware of what you're getting yourself into. Does a contract have to be in writing or fancy to be enforceable? No, it doesn't. Oral contracts are enforceable. I'm working with a client right now where it was all agreed over the phone or in person. It makes it harder because it's harder for us to prove that this was what was agreed upon, because there's no written format for that. Text and emails do count as writing, so there's that. Someone has mainly done an oral agreement, but there's some written texts or emails we can use that will strengthen our ability to clarify and get the contract in our favor. But again, oral contracts are enforceable. I definitely encourage you to make sure there's a written contract, though it is, as I note here, it's much easier to prove what you accepted and what you thought you were getting into for the contract. They also don't have to be fancy. They can be really simple. Unfortunately, when they're simple, maybe there's something missing. We'll talk about kind of a checklist there. I know a lot of clients don't want, 20-page legalese contract. And I personally hate that too. I wish we could just talk in normal terms that everyone could understand, but that's just not the way it necessarily works. And even if it's normal terms, which I certainly strive for, there's just different protections that, it's just hard to leave out of a contract. But again, if you have something simple, it's still going to be a contract. So we can still use that. The only exceptions to oral contracts are something that's an acronym we learned in law school called MyLegs. Anyone that went to law school will remember the MyLegs acronym. It stands for, marriage. Marriage contracts are not enforceable if they weren't in writing. There's not proof of the marriage, with a signed marriage license. Year, if it can't be done, if it physically cannot be done in less than a year, that has to be in written form. Land also, you don't have an oral contract for land. It has to be in writing. If you're the executor of someone's estate and you make a promise, that has to be in writing. If you're selling goods that are $500 or more, I think it's 500, more than 500, not 500, but more than 500, that would have to be in writing as well. And then if you're going to be a surety for someone's loan, if you're making a promise, if I'm promising to pay Mike's loan, if he doesn't pay it, that also has to be in writing. These are things that, are just by nature a little more complex or creating a special obligation to someone, and they would need to be in writing. But aside from those scenarios, again, oral contracts would be enforceable. The shortest valid contract was found to be in a cocktail napkin. Sometimes you see that in movies and shows, and that's certainly possible that if you sketch something on a contract and you jokingly signed it, and sometimes what happens, people have been drinking, and there becomes a question, were they under the influence and able to actually enter into a contract or not? But typically, courts tend to favor the fact that you still signed it unless you were, just completely, falling off your chair, intoxicated. Then you probably would have a good chance to get out of that contract. But that case was like back in 1885, and the court actually upheld that. So keep in mind, again, writing in writing is better than not. But don't think that you can't pursue something just because you didn't put it in writing. So the do's and don'ts, I kind of try to phrase it this way. So I really do encourage you to hire a lawyer to review your contract. I just talked to a client the other day who has got herself into a bit of a mess. And part of it, is like I said here, is the other party's attorney drafted. When I draft a contract or any piece of paper or document, I'm drafting it to benefit my client. I'm not approaching it to benefit both parties. And that creates a conflict of interest if you're having one attorney draft a contract that affects different parties, because there's no way that you can do the best for your client, but you're also balancing everyone else's needs. That said, sometimes we are putting terms in that benefit both parties, that there's mutual termination clause or mutual liability and indemnification clause. So there may still be things that benefit both, but it's not the intent to create a contract that benefits both parties. So it's always dangerous to sign a contract without having an attorney review it, or if you're very sophisticated in contract knowledge and language, and you're used to dealing with contracts, and that may be sufficient right there. But don't blindly assume that that contract is going to benefit you, and that's what my client did. It was written so that she's backed herself into a corner. And sometimes you can claim that it's really unfair balance of equities in the contract. But if you have a very sophisticated party and one that's not, it could be potentially an argument to see the contract voided, but I would not rely on that. So again, please don't sign anything without having either an attorney or someone that's very knowledgeable in contract law review it, or that you just take your time and you just really nitpick through the whole thing, research parts of the terms, and make sure you really understand what you're signing. Because once it's signed, you may have taken your other options off the table. Do be clear. I see this a lot, and I know lots of attorneys are in court fighting over ambiguous contracts. Typically, an ambiguous or poorly drafted contract is going to be held against the drafter. But it creates confusion for everyone, right, the whole time. And sometimes the court, and actually sometimes I see provisions in there where there's a waiver of ambiguous terms being held against the drafter. So you may see that sort of thing, and then you don't even have an argument that this should be construed in your favor because you didn't draft it. Because again, normally the court would find that the draft is responsible for anything ambiguous, and they would find in your favor for an ambiguous term. But if there's that little provision in a contract that says, this is off the table, we're not going to blame the drafter, then there out goes that argument. So I think what I see a lot of times is capitalization, like the having the first letter capitalized, like services with a capital S. that means that that's an actual, legal term in the contract. Sometimes you'll see later on, you'll see a small s, and that creates some, ambiguity as to does that mean something different now because it's not capitalized? Are you using terms that are clear to what you mean? Sometimes like comments like it'll be paid upon the client's satisfaction of receipt of the product or service. Well, how do we determine the client satisfaction? Do they have to accept it and not respond or notify you of a problem for a certain amount of time? Is there a certain like minimum level of satisfaction? What does that really mean? So please carefully review your contract, and it's also helpful to have a neutral party look at it if you're not using an attorney, or even if you are, and see what they think it means. Because I'll read a contract and I come up with my own interpretation of what I think it means, and it may not be what my client thought it was. So because you're in the middle of it, right? You know what you meant. The other party knew what they meant, but a neutral party like a judge is not party to that conversation, and it may mean something different to them. And that's ultimately, if you go to court, who you need to impress upon is the judge, that this term is, this ambiguous term is in your favor. And again, if it's not obvious to the neutral party reading it, then that's going to be a problem. So always, define your terms in your contracts. And sometimes you'll see contracts with a whole section of the definitions. I think that's useful if you have a number of different factors happening or issues in your contract, or if it's very complex. It may not be necessary in some instances. Sometimes we'll just define them actually in a sentence. You'll see it'll be in parentheses, quotations, and it'll say services, capital S, meaning that whatever we said previous to that is the definition of services. So you can put that simply into the actual sentences. Or again, sometimes you see contracts that have a page or two of definitions. We see it a lot with statutes as well. Like New Hampshire, our statutes, which are our laws in New Hampshire, there'll often be a definition section as part of that statute, which defines what they mean. Like, for example, labor laws, there's a definition of what an employer is. There's a definition of what an employee is. So there's clarity in the law, and we want that same thing in contracts too. Just on a note for any chat, please, I think Mike noted it already too. Please don't hesitate to put things in chat if you have questions. We'll hang around for a bit at the end. If there's anything that comes up, happy to talk about that. So please note your questions in the chat as we go if they arise. Also, really important to be consistent on the same tone as the previous slide. Again, I can't tell you how many times it becomes a debate about what a word actually means, especially if someone's drafting it quickly, and they may fail to properly, capitalize this, because I could create an argument that these are two different things. And if you, haven't been consistent throughout the document, then that's going to create potential, argument there that, this thing that you were arguing about is not the thing that, was this part of the contract. And again, it just creates areas for argument and dispute. And we don't want that. My goal is, I prefer risk management. Like the saying, it's better to have an ounce of prevention than a pound of cure. And that's so true. It's much more expensive when you get into disputes of contracts. And if we could have just spent that time and a little bit of money, having a solid contract, doesn't mean you're not going to have a dispute later on, but at least that dispute will be a lot smoother sailing when there's a good contract at the core. Key terms again, and use them consistently. Sometimes I see people, switch terms back and forth. They meant this, and then they used it later on, which is maybe the slang term for that, or just a shorter way of saying it. But again, those sorts of things they sound like petty, nuanced items, but they really can create problems later on for you. So, make sure, maybe it's not you, maybe you have someone else who goes through it and kind of circles any of the things they see like that. That could be helpful when you stare at a document for a period of time, especially if it's like, I just read a 45-page contract a couple of days ago, and that was mind-numbing. I will tell you that. It's not fun. But it's, it's easy to maybe miss something if you're delving in, to a really meaty contract like that. So again, having another party look through that and catch things can be helpful too, to make sure you're using that consistency and that capitalization is in place. Do protect yourself. I can't say this enough. I work with people in business and employment law. So it's mostly on the business side where I see these issues, sometimes on the employment contract side, but where, again, I just had a call this morning where someone is backed into a corner with a partner they don't want, and they're leasing property from someone else who's also causing problems. And there's no operating agreement, and there's no proper contract on it to offer them any protections. And it's a shame to see. All we can do now is just control and mitigate the damage as much as possible and extract them out of the situation. But it's going to cost some money to do that. So again, not that we want to walk around paranoid, but we do want to be aware that, the only person who looks out for your best interest is you 100% of the time. And so you want to make sure that, you're well protected. And that's something that we'll talk about as we go here in a few minutes. And that's a goal, for attorneys, is to make sure we're protecting our client. Also, not just protecting you per se, but also complying with what you expected from the contract. There's often lack of clarity with people, especially if they're friends. And like this person this morning, they've known the person for a long time. They didn't expect this twist like this to happen, and suddenly their relationship to degrade like that. So, they knew what they expected from the contract in the beginning, and the other person's not living up to that. So that's not at all in written form. So don't assume that the other person has the same expectations as you do, or the same 100% commitment that you do. Also, don't leave out oral discussions, because almost every contract has an entire agreement clause. And that means that clause is saying that everything in this written agreement is everything that's been agreed on. And that's the only thing we're gonna be following and enforcing. And you're like, well, geez, we also talked about this. Like I have someone who's prospective client right now. They may or may not bring us on, but they were promised something around patent rights. For a product they had, they've developed most of it, and they were promised patent rights, but they never got that in writing, and their contract has the entire agreement clause. So now the other party is saying, look, you signed this agreement. It says right there, everything we agreed upon is in this agreement. And so occasionally, maybe outside conversations might be brought into it by the court if there's ambiguity, to help clarify it. But typically, they're not going to use something you said outside of the contract and let you bring it in and now enforce it. That's not going to happen. It may just be the conversation is used to clarify something already in the contract, but you can't bring in new stuff like that. So again, be careful, read it carefully. I find a lot of us, and I go to this myself too, is we're often in like the rush mode where we're trying to, when we multitask, which we know is not helpful, because you're not putting 100% of your concentration into something, and you're actually less productive. You may know people, maybe you do it yourself. I'm occasionally guilty of it too, where you've got like 5 things going at the once. And I'm trying to break myself of that habit, because it's just not, personally and professionally, it's just not a good use of your time. So making sure that, you are spending, carefully setting aside time, and you're spending time to carefully craft this contract. And then again, hopefully you have an attorney review it, and then you can make the final edits before everyone actually signs it. So kind of a checklist, and we could go on all day about this, but just some kind of high points. Again, I can't emphasize enough reviewing it, and edits. Don't be afraid to go back and forth. I have a poster in my room, in my office here. I don't think you can see it, but it's kind of in the shot, but you can't really read it. It says you miss 100% of the chances you don't take. And Wayne Gretzky was quoted saying that you miss 100% of the chances you don't take. And I know they talked about it in the office too, as a joke, but it's serious. Like if you don't try to negotiate, then how do you know you couldn't have got what you wanted if you just asked? So the other day I worked with a client. We made a list. I went through the contract ahead of time. It was 45 pages long. And it made a whole list of items that I wanted him to be aware of, and then items I was concerned about, like, for example, a 60-day payment term. That's a long time for a small business to wait for payment from a larger company. And often, they try to force these longer terms in because, they have, more layers, right? More departments, more people, and they just, the volume of invoices coming in, they want more processing time, which I understand. But on the flip side of that, especially if you're a small business, 60 days, you have to carry payroll in the meantime before you get paid. That can be really a burden. A lot of companies, and I suspect there'll be people talking about this and other programs, and this program that we have going this month, that they'll talk about, the cash flow challenge for businesses. And so, really negotiate on that, bring it down if you can, to 30 days or whatever you can. I like to use either like due upon receipt or like 15 days. So it's top of mind for people. That's not going to be realistic with a larger company because again, they have more, hoops to get through to get the invoice paid and the check actually or EFT going out. But negotiate on payment terms, that can really hurt you and affect you. And again, the courts, even if they're likely to enforce a contract, even if you say, well, I didn't actually read it. Say, well, did you sign it? What was your role in that? Well, yeah, I signed it like I'm one of the parties to the contract. Well, they're like, well, tough then that you didn't read it. That's, your own detriment that you didn't actually read through it carefully. Key obligations, clarifying duties, again, like with the payment terms, is it 60 days? That's a lot. What do you want to negotiate on? Obviously, you're picking your battles here sometimes so that, you're not maybe negotiating on everything. There's some things you can live with. And that's my client's case. He says, well, we can deal with that. But there's certain things he wanted in there where if there's like Sunday work, for example, they work with union workers and there's a double time pay required for that. He wanted, a provision in there that the client was going to be responsible for any Sunday work if they had emergencies. Those sorts of things are important to him because they're going to hit his bottom line. Again, the services, what exactly are you providing? I worked with an MSP provider who, well, it's redundant. That's what MSP stands for, Master Service Agreement, and the provider part of it. He had kind of assumed the services he would be providing to people, but I was looking at it as a neutral party, and I thought, geez, like I'm presuming that you're going to do this and this and be on site too. He said, well, no, we don't do that. Like, well, we need to revise this and make sure it's really clear. The services, because again, what you're thinking and talked about, but if it's not in that written contract, that can come back to bite you. How are changes handled? Can there be a change? And if there can be a change, both parties should be signing it in writing. Both parties should agree and have it signed in writing. That provisions should be in the contract. How is insurance, being handled? Are there insurance requirements and deadlines? What's the deadline? Sometimes it's too vague, and that could lead to either this miscommunication, some frustration, or an argument there's been a breach of contract that you missed the deadline. Confidentiality terms, super important. It may be mutual confidentiality provision. Yesterday, I talked about trade secrets and confidentiality, and it's really important that you address this and put it in legally enforceable contract. So there's a duty to people to keep your stuff confidential that you're going to be sharing. And that it's okay, for you to agree that you'll keep their stuff confidential. If I drafted the agreement for you, it's going to probably be a one-way confidentiality agreement, because if it's mutual, it does put a burden on you now, because what if, one of your best employees, inadvertently shares confidential information about your client and now you're in breach of contract. So, but usually both parties are going to want that to be mutual protection there. What about licensing? I have an example later on where if there's no discussion about licensing or ownership around any patents or other IP, there's going to be a problem later on if you don't have full ownership, or if you have a non-exclusive right to use something. That means that company can, if you have a non-exclusive right to use a product, it means that other people can use that product too. You don't own it, and at that point you only have the right to use it. You don't have the right to be the only one using it. So licensing terms are really important if you're dealing with anything that could be potentially IP, patents and trademarks and copyright like that. So be clear, especially patents is where it comes in most problematic. Again, identifying like who's the owner and who has the license. Is there any license? And cutting out anything that you had knowledge of before. Like if you're coming in there as a service provider, you don't want to like lose your confidential information or trade secrets or patent rights or any copyright. You don't want to lose some of that you already had in this new product you developed, and then you lost the whole thing. So you want to have a section that talks about how everything that you have now is still yours. It's just this new modified product that has the other party has ownership or licensing to. I know this is boring, so hang in there with me, but it really does come down to protecting yourself, and you have to get into the nuances sometimes and then once it's done, it's done. Liability identification, that's just really important. Is there a limit on liability? I have a case we'll look at towards the end where it was not even. You know, the one party had liability of only $500, the other party had unlimited liability. So you want to determine, and commonly you'll see a provision that says, you know, our limited liability is to only like the last 12 months of invoices or, you know, paid contracts, or payment, however you phrase it. And so it's limiting to just what you made from that client for the last 12 months. That's your limited liability. Now, sure, they can go to court, maybe bust out that provision, but at least gives you something to work with and hopefully discourage the other party from trying to sue you if there's a limited liability like that. You also want to identify what you're going to be liable for. It's hard to get out of gross negligence, but other things that, you know, you want to make sure that you're not going to be liable for should be spelled out in there. Indemnification is important too, because you don't want to get, you know, pulled into a lawsuit where you're, you know, you're kind of an innocent party because you were, you know, in this contract and your name was out there to the injured party, you know, some other injured party, they sue you too. And if that happens, you want to have an indemnification clause where, you know, the party to your contract is going to have to reimburse you for your out-of-pocket, you know, legal expenses, you know, any damages you found responsible for, so that, you know, you're not getting put at risk constantly. I see this a lot with, for example, I have a lot of healthcare clients, and, you know, we always put terms in patient agreements around, like, and like the parent agreements, if it's children they're working with, that the parents and guardians will identify my client in case their child, or if they're an adult, them, actually causes harm to a third party in the building. You know, say you have, yes, you're providing counseling services to someone, and, you know, they shove someone down the hallway, maybe the CPA, because they hate CPAs, or, you know, or a lawyer, which is more common, and they cause some harm, and then that lawyer or CPA sues you too, because you're the reason that person was there. And if that person wasn't there, they wouldn't have got hurt. So you see where, you know, you can get pulled into these things unexpectedly, and at significant cost. So identification is an important term to have in there. I call it the go clause, exit terms. You know, how do I get the heck out of this? Sometimes it's not gelling between you and the other party. And unfortunately, I mean, I don't know what the stats are. I know like divorce stats supposed to be around 50%. I don't know if that's accurate anymore. It's the last I remember hearing. So I wonder how much partnerships and contracts, how often they go bad like that, what that stat is. But if you had a good, clean way to get out of that contract, that could avoid a dispute as well. So having, you know, the terms in there. Sometimes they see one-way contracts where, you know, only Mike's in a contract with Liz, and only Liz can get out of the contract. Mike's stuck. That's not a good result for Mike. If only Liz has the go clause and Mike doesn't have that. So identifying, and that also is there going to be notice. Sometimes, you know, you want written notice before a contract's terminated. You know, say I decide to you know, file or notify Mike that I want to terminate our contract. Is it beneficial for Mike to have you know, some notice in there, you know, 30 days notice, 10 days notice, or does it make sense to terminate the contract upon receipt of the written notice? Think about what you're doing and how it may be impacted, and how maybe you could wrap something up in that notice period, make more revenue, or maybe it's going to just get you into a mess if you keep going on a contract that's terminating. You know, maybe you don't want to keep going during that notice period. So you don't want to have a notice period. You want to just have it upon written notice, it terminates, you know, immediately. And of course, that the other party is responsible for payment for services or products provided, you know, through that date of termination. Is there a right to cure? You know, do you want to have a right to cure, so that if Liz tells me that there's a problem with the services I'm providing, you know, do I have a chance to fix it? If it's Mike that, you know, hasn't paid his bill, and it's going on, you know, 30 days, we had payment terms due upon receipt. You know, I might say, send a notice to Mike and say, hey, I have to terminate the contract. You know, you haven't satisfied or, you know, met the payment terms. And do I give him a right to cure that period? Like, he's got to pay me within 10 days, and then we're back on track with the contract, or is it done? So you want to think about, like, how is that going to impact you? Do you want the right to cure it? And it can work both ways. So if that, maybe you want it, but you don't want the other party to have it, you can try writing like that. If they have an attorney, they may note that. And I would, for example, I would say, like, look, this is a one-way right to cure. That's not good for you. So we talk through those kinds of scenarios, like, you know, looking down, like, how is this going to impact you? And that should be in the contract. On a similar note, like dispute resolution, I've been a big fan of mediation lately because I've had some good successes in it. Right now, we have 5 cases in court, and it's like a 2-year wait. And we're still waiting on Massachusetts, a case that there's been a motion to dismiss. It's been like 3 months, and there's no hearing date yet. So the clients are like, "What's going on? What's going on?" Like nothing's going on, and that's like we're kind of we're stuck right now in a waiting mode, and it's just very slow. It's expensive. So I like to encourage people to consider mediation, and putting that in contract can, require that step. And sometimes it fails. Sometimes I actually just took a case where they were unsuccessful in mediation, and so now they're proceeding with litigation, and they weren't able to negotiate. The other party wasn't being reasonable. That's my client's perspective, and I can certainly see that. I see that sometimes where people just aren't willing to meet you halfway. I mean, basically mediation, like you have to kind of get to the point where you're at your most, your comfort level, your most uncomfortable comfort level, if that makes sense. How you're giving up and what you're giving up to get to a point the other party will agree to. That may not be possible with some individuals. They may be too emotionally involved in it. They may not see that they did anything wrong and you're the problem. So, it's not the solution for everything, but I think it's good to perhaps calm people down before they, one party goes and files a lawsuit. And mediation just, is not binding. So again, if it doesn't work, it doesn't hurt your position at all. At least you tried it in good faith. There's a lot of great mediators out there. So think about that provision. And then arbitration, not a fan of that. I think that, I hear from other attorneys too, it can be expensive. It can take a lot longer, the mediation, and also it is binding. So if you don't like the result from the administrative law judge there, the arbitrator, then you're stuck. You can't appeal it unless they had gross misconduct or some gross conflict of interest. There's a list of exceptions, but they're probably not going to be as applicable. They won't be applicable to everyone, and then you're stuck with this binding arbitration decision. So not a big fan of arbitration. And then lastly, on this one here, who pays the legal fees? Are both parties going to pay the legal fees, or is it prevailing party? I do get nervous about prevailing party provisions, because that means, that, if we take Liz to court and she wins, and maybe we put the contract term in there, prevailing party wins, we think we're not going to make any mistakes, and Liz sues us. And then now if, she wins, we have to pay not only our legal fees, but her legal fees. So it's a risk. I think it depends, really it's very nuanced on the situation, the industry, the details of the transaction and agreement, whether or not you want to risk prevailing party. And a lot of times people ask, well, can I get my legal fees back if I win? And not necessarily. Your legal fees have to be addressed, in the contract, or by statute, or it may be decided by a court if there's, punitive, or as a punitive measure, or, if the other party had bad faith, or, it's inequity. There may be some judges that will order the legal fees to be paid. But if it's not already in a contract or statute, you're probably not going to get them. So keep that in mind. Do you want to talk about legal fees in there, or is it each party pays their own? And that may override a judge's decision to order one party to pay legal fees too, potentially. And again, what I found is that, every judge is different. So you can't anticipate how things are going to play out. The best you can do is really try to, cover it, all the terms to the best of your ability, and hope for the best. Negotiation, again, talked about that, up here, when you're reviewing, I highly think that's a bad arrow. I encourage you to review it, and like I put a Google Doc up at the same time, and I'll just start, pinpointing down, like, okay, I want my clients to know about this. Here's the things I'm concerned about. And then we may go through that, and they may pick out like, 2 or 3 things that they're really stuck on wanting to negotiate. But, again, just remember, you miss 100% of the chances you don't take. So if you don't even try to negotiate, then you're not going to get it. And I always tell my clients, like, look, you can just blame it on the lawyer. Just say, like, my lawyer is such a pain. They really push them for this. Like, you can blame it on the lawyer. Everyone knows lawyers are sticklers for certain things, and it's easy to blame us for that. If there's a certain provision, because you don't want to make it awkward, you can kind of like blame it on your lawyer that they really, really say, we have to have this sort of thing, and may take off some of the adversarial feeling that some people have when they deal with what they perceive might be sort of conflict here. But really, it's just business to negotiate ahead of time. So I encourage you not to skip it because you don't want to have that conversation. Roll-up contracts, there's many purposes for them. I went through all of these yesterday as well. I know that that recording is available, but in any of these forms of contracts, everything we just talked about in the checklist is applicable here. I mean, obviously, like an NDA, you're not going to get into payment terms, right? But a lot of the things we talked about are applicable here, especially making sure there's no ambiguity, that you've just discussed, dispute resolution, anything else that is important should be in these contracts. So we're going to look at some examples of cases gone wrong in just a moment as well. Yeah, that's pretty much what I wanted to just kind of think about is like the different forms of contracts out there, and keeping in mind that a business contract between you and your customer is going to be just as important as anything else in here. They're all legal contracts. Sometimes on this note here, sometimes you see these that are put in an employee handbook, and that won't be enforceable. An employee handbook is, well, it should have a disclaimer that this is not a contract. This does not create a contract or obligation of employment, that this is at will. So the nature of an employee handbook is such that it does not create a contract. So even though you could fire someone if they violated your non-disclosure or confidentiality clause, doesn't mean you can take them to court and sue them for violating it. So that needs to be a separate legal document that you created, that legal obligation for them. And typically it's around that they won't share your confidential information, and they get the benefit of working for you. So that's the consideration, trade-off. Everyone gets something from it. But I know it sounds like kind of nitpicky to have contracts for everything, but again, I've just seen them so many times blow up. And the other one I would say that should be on here is an operating agreement, actually, and I can't probably spell that now. It's not going to work, but operating agreement would be one that you want to be considering. It's not really a contract per se, but it certainly works that way. It provides guidance and agreement on how you handle things when things are good, which is the time to decide on that, not when things are bad. No one's going to be cooperative when things are bad. So let's walk through a couple examples, and then we'll leave, at least a few minutes to talk about any questions. And then this will be available via recording as well. And if you have something simple you want to ask, you can always email me. My email is on the slide too, or at the end of the slides. So in this case, this is a non-compete. It's an agreement that has a non-compete clause in it with their employee, and it's unreasonably broad. You see this a lot. They only work in New Hampshire, but you've got a national non-compete clause. They can't work nationally in that industry. That's way too broad. No court's going to enforce that. And it has to be like, usually it's a year is max. Sometimes you see non-competes for 2-3 years. Again, that's not going to be enforceable. So the only exceptions would be like if you bought a business and it's the previous, the founder, that has some exclusions around non-competes being for longer periods of time. So that's not unusual there. But if it's a regular employee, you can't have this geographically broad non-compete. You can't, have it applying to areas they never were even involved in. The whole idea of a non-compete is to protect your legitimate business interests. And the courts will look at this and say, how is this contract protecting your legitimate business interests if Liz only worked in this part of your company and you've got the non-compete here? This is not going to work. So sometimes I have clients that are going on to hire someone, and I always ask, like, does the employee have a non-compete? Do they have non-solicitation? Do they have NDAs on confidentiality or confidentiality provisions? You want to be really careful that you're not violating inadvertently that document by hiring someone on. Same thing works with trade secrets. We talked about that yesterday. You want to be careful as the business owner hiring someone, like, you want to know, like, what do they already have signed, because you don't want to get in the middle of any disputes there and inadvertently get pulled into that. So here, this agreement was just way too broad, and it restricts well, in this case they have company, but usually it's an employee that to pursue new opportunities. It stifles growth, limits the future prospects, and like in California, they don't, non-competes are banned. Federal Trade Commission at a federal level was one to ban it. That was put on hold by a federal district court. I think it was Texas last year, if I'm recalling correctly. But New York has a law pending. I'm not sure if it's taken effect yet. And then like Massachusetts requires garden leave. So if you don't pay the person half their salary during that enforceable time period, you don't have an enforceable non-compete. And I see is that where companies are from other states and they're just not familiar with the state where their employee is working in, and that's the state law that's going to apply. If Mike's working in Idaho, from home, Idaho law is going to apply. So just be mindful of where your employee is sitting as well. You can have a non-compete clause, for other businesses. And that was one problem that one of my clients has right now. And he's getting ready to sign it. It's a really good deal for him, but it does have a 1 year non-compete for him. And it's for the industrial, it's phrased as any of their competitors. I said, we need to know who these competitors are, because that may be problematic for you if there's only like 10 key companies in this particular field, and it's got a relatively niche field, engineering. Then who are you going to work for if you've got this non-compete? So again, comes back to stifling the ability to make money and work. So be careful, because if you're relying on something to protect your business when someone leaves, or you finish an engagement with another company and now it's not enforceable, then you're really out of luck. Missing contract terms, like again, example here, payment is due upon completion. What does completion mean? It's not defined. So that could be up to my interpretation. I'm not going to pay you until it's completed, and I may be very picky and I have a million edits to it. Now, you're not getting paid for months on it. So be really careful about that. Missing termination clause, again, I've seen some where there's just no termination. So it's like, okay, was this forever? Now we're going to be here 80 years old working together on this contract. And when does it stop? There needs to be a stop time. Sometimes it's the term that identifies like it's a term for a year. Often you see like the automatically renewable term. So watch out for those if you don't want that to be this to roll over and be kind of a continuous contract. That may not be what you want. Maybe you don't want this client for that long. Or maybe you want to increase your prices and now you're kind of locked into the same price as the contract. Or on the flip side, for the customer, you might not want to, have that kind of commitment like that. And then again, when things go bad, like you're realizing like, I don't like this client, I don't like this customer. I really don't want to be in business with them anymore. How do you get out of that? And if there's no term, clause in there, it may be difficult to get back out of that contract. Might be stuck with it, until the end of the term. Unbalanced liability provisions like this one I seen before, where there was liability was capped at 500, but the client's potential liability was much greater. So we want to make sure it's balancing, protecting you, and it's not just one-sided protection. The automatic renewal traps, again, missing a notice window, and now you're locked in for another year, and maybe the contract said that the rates go up 10%, and you missed that window, and now you're stuck. So those are some of the examples where you see that can be problematic. This is a big one here. This scenario, a big corp hires design code to design a new product, create a brand name, produce a promotional video. The contract is silent about who owns the IP. So the problem for a big corp is they just paid Design Co. $100,000, and now they don't necessarily have ownership of this product or any of these, the name or the promotional video. They may not be free to commercialize it. They may not even have the licensing agreed upon, so maybe they can't use it, and that would probably be a major oversight and maybe a reason to dispute the contract and void it if you're paying to get it and then you had no licensing. Those are things you want to be thinking about, and you may have to negotiate additional agreements or pay extra fees to get that ownership or license that you want, and that could be hefty. So think about in your contract, who owns any IP that's going to be created during the relationship. I mean, again, your own prior IP should be marked out. If it's an employee, these are important to identify. When does the employees, when do they have ownership of IP? If they created it outside of work, if they use your resources, you're going to probably have at least a license to use whatever they developed. So it's a two-way street where if you're an employee or a contractor, and you're at a company too, you want to protect yourself with your own IP that you might develop, outside of the contract. But again, if you use your client's resources or your employer's resources, and they generally going to have right to license it at the very least. And that could be problematic if you want to sell that patent later on, and there's a right to license out there, meaning someone else can use it even though they don't own it. So those are the sorts of things that I want you to be thinking about before you sign a contract and as you're developing contracts. So Mike, that's about all I have. Are there any questions?
We do have some questions. You went over so many wonderful things. Do you want to take a breath for a second?
No, I'm good. It's kind of
okay.
issue spotting today. So it's not like you have to remember all this stuff, but you'll have the presentation. You can kind of think about it. But no, go ahead, Mike.
Okay, great. So I think that we're going to have some people drop off just because of the nature of the timing, but please do stay on if you want to stay on for Q&A. We have a lot of small businesses that come to us. They're looking to be really cost effective. I'm wondering if you could maybe briefly just speak to being really when and where you should be cautious around using like templates that are out there or services that tend to sell boilerplate contracts or et cetera.
And they're good starting places. You could even use like ChatGPT can draft a decent contract for you, but it's not going to know necessarily the law, or if it thinks it knows it, it's not quite spot on, and it may not still have the protections that you need. So I think like I'm happy to review and edit a contract that comes to me. I don't have to start them from scratch. I think some lawyers, only want to use their contracts, but I'm okay editing someone else's contract. I review it and I would, red line suggestions, flag comments, and we'll discuss it. So I think you can do that, and that may keep some of your costs down on the legal side.
So you would say using it as a starting place, but always
Yes.
make sure to review it, bring it to a professional before actually making use of it, putting it to practice. Okay, great. One thing I'm going to have you do is advance to the next slide with your contact information, because I have you spotlighted. I just want to make sure that if anybody does want to follow up with you after the fact, they do have that information. We did have a couple questions from consultants that are just getting started. And let's see.
I see one that says about family members. I wouldn't treat family any different than a stranger, honestly, because families get in disputes too, and sometimes hate each other forever and ever. Hopefully that will happen to you, but I wouldn't treat family any different than, arm's length individual that's entering a contract with you.
I think that there's a follow-on to that question around this being the first commercial lease agreement and things to possibly watch out for, because there's some familiarity with residential, but not a ton of experience with commercial, if I'm reading that property one correctly.
I see Mr. mentions AI use in contracts too. I actually, in our engagement letters, we always indicate that we are going to use AI to benefit our clients' cases, because it can often help with efficiency. It can help you start research. It can help generate some suggestions or terms. So, but it's all around efficiency with the client. So I'm a big fan of being transparent. And if you're going to use AI, I think it's good to tell people that, so there's no surprise later on. I think that everyone's using it now, but I think it doesn't hurt to have a reference to AI that, if it's applicable, to put that in a contract. Also, don't promise anything about, data breaches, security on that. No one's untouchable. So make sure that you indicate, and make sure you are doing what you say in there. That's super important. You don't overinflate what you're doing. Because I had that one problem. Someone are you doing all these things? He's like, well, we're striving for that. Like, let's not put that anywhere in writing, because this is great internal document, but we don't want to put. He was going to put on our terms of use on his site, and that's obligating you to this when you don't even need this. This is what you need, and this is what you're saying. And if you don't do that, then you're creating deceptive terms and promises, and so you just never promise on data breaches too. Sorry, Mike, I just wanted to kind of speed through a couple.
That's okay. I think you hit on all of the ones that we had in the chat and that were kind of out there. Amy, thank you.
There was one about, it's a little more compounded question too from someone I see about leasing and all, and that's a little more nuanced too. So I couldn't really give a good answer on that question about leasing a unit in a cafe. And again, I think it's important to put everything in writing, whether it's your family or a stranger.
Awesome. Thank you, Amy. So much great information and content today. I'm sure that everybody's head is spinning because there's just so much in there that was so great. If anybody does have follow-on questions for Amy, she did share her contact information. We do have a number of great webinars in this series that are coming up over the next few weeks. If you haven't checked them out, please do take a look. There's so much great content,
Yeah, there is.
as well as the many programs that Liz touched on at the beginning of this webinar, such as the LEAF program. So if you have not made your way over to our website recently, definitely wander over to nhsbdc.org. Keep an eye out for our newsletter, or touch base with your business advisor if you have not done so recently. There's all kinds of great resources available. Thank you so much for joining us today, and have a great day.
Thank you, Mike. Thanks, Emily. I saw your note. Take care, everyone.
Thank you.